Which cryptocurrency is being attacked by the SEC after XRP? How long will crypto holders believe in Ripple? How much will XRP cost in mid-2020? 3. We will answer all these questions. A banking law expert has pointed out the problem with the use of the Howey test to determine what is or isn't an investment contract, which could lead the SEC to lose its war against crypto as the cryptocurrency community eagerly awaits the outcome of the courtroom standoff between Ripple and the United States Securities and Exchange Commission, SEC. According to a thread of tweets published by the legal expert on April 8, Howey isn't the best way to decide what is an investment contract, as evidenced by an argument from the motion to dismiss in the SEC lawsuit against the former Coinbase bosses Ishan and Nikhil Wahi. He emphasized the importance of having a contract, having legal duties after the sale, and having the ability to split the profits. If this is the litmus test, then virtual currencies and tokens are very certainly commodities, falling within the purview of the Commodity Futures Trading Commission, FTC. Furthermore, this argument has been used in previous court cases, including one against the cryptocurrency exchange Coinbase, and would be a severe blow to the SEC's power, not only in terms of regulating the crypto business, but with far broader implications. On the other hand, on April 9, John E. Deaton, a legal expert and amicus curiae for the blockchain startup, highlighted Phillips' tweet, adding that the Ripple defense team had previously presented this point and that we are waiting for Judge Torres' ruling any day now. Coinbase used this reasoning in its amicus brief for the case as, well, former lawyer and co-founder of permissionless Layer 2 platform Evernode, XRP Scott Chamberlain, stated on April 6 that the lawsuit would have settled long ago if the SEC had just alleged that Ripple offered XRP as an investment contract rather than a security. In response to SEC Chairman Gary Gensler's video, Ripple's International Policy Council, Susan Friedman quoted Deaton as saying, "Crypto can't be an investment contract for those who acquire a token on the secondary market for consumptive use, and with no knowledge of, interest in, or rights from whoever previously sold it on-chain." Feinbold reported on April 8 that attorney Bill Morgan had disclosed that and SEC expert had stated that changes in the value of Bitcoin, DTT, and Ethereum, VeTheo and Ethereum, that might account for as much as 90 of XRP price swings since mid-2018. The current price of XRP is 51 cents, which is a rise of 0.36 in the previous 24 hours, but a decrease of 2.79 over the week. Despite this, the digital asset is still holding on to the gains of 36.5 achieved over the last month. A new development in the SEC's action against Ripple, a blockchain company, has the potential to dramatically affect the ultimate result as the cryptocurrency world awaits the summary judgment. The SEC's expert has stated that changes in the values of Bitcoin and Ethereum have been responsible for up to 90s of swings in the price of XRP since mid-2018, as reported by lawyer Bill Morgan in a tweet on April 7. He hypothesized that if the SEC's premise about its experts' knowledge is correct, it may mean that Ripple is allowing the value of XRP to be affected by the swings in the value of Bitcoin and Ethereum. Therefore, the SEC tries to prove the claim by providing proof that XRP's value is affected by Ripple's price announcements. Morgan's point is bolstered by the fact that the value of Bitcoin affects the value of most cryptocurrencies. Morgan also noted that the view that XRP is a security and that Ripple's large XRP holdings imply centralization of the XRP ledger remains. Importantly, the SEC is suing Ripple for offering XRP coins for sale without first registering them as securities. Ripple is seeking to defend itself by having the regulator's remarks from a lecture he gave in which he referred to Bitcoin and Ethereum as securities unsealed. The SEC claims that investors are counting on Ripple's legal efforts to succeed, and Morgan agrees. The lawyer further clarified that investors do not expect Ripple's commercial activities to earn profits from XRP, but rather on the company's legal efforts to emerge triumphant in the SEC litigation. Contrary to what the SEC believes, Ripple's legal efforts defeating the SEC's lawsuit, should it be successful, mean that investors were right to put faith in the company? Jeremy Hogan, another advocate of XRP, used Morgan's comments to forecast a surprising verdict in the case. Since even the SEC acknowledges that Ripple's activities after mid-2018 had no effect on the token's value, Hogan hypothesized that if the presiding judge opted to split the baby, she might determine that XRP sales after mid-2018 were not securities. Even the SEC admits that Ripple's activities have had essentially no influence on XRP's price since mid-2018. Thus, the judge, in the Ripple case, if she wanted to split the baby, that's a dreadful expression, isn't it? May decide that sales of XRP since then were not securities. Hogan said that the verdict might have far-reaching consequences, including the possibility that Ripple would have to pay a fee just to keep doing business as usual. As the sole cryptocurrency with a well-defined legal position, Hogan pointed out that XRP may have an impact on how other digital assets are treated by exchanges. Meanwhile, the timing of the summary judgment remains a matter of conjecture. The first estimated timing for the lawsuit verdict was the first quarter of 2023, according to some legal experts. The overall value of XRP and the cryptocurrency market might be affected by the verdict in this case. XRP is up around 1 on the week, trading at 51 cents right now. A district of Massachusetts judge granted the SEC's move for summary judgment and denied the defendant's cross-motion for summary judgment in the lawsuit against Commonwealth Equity Services, LCLC, on April 7, 2020. 3. The agency claims that this ruling proves the SEC's allegations against Ripple for violations of federal securities laws, including substantial misrepresentations and omissions of conflicts of interest. The SEC brought suit against Commonwealth and its CEO, John Roney, in 2019. Success for the SEC in court. Most notably, the court did not buy the defendant's procedural argument that he had not received sufficient notice from the SEC of the disclosure duties asserted in the complaint. The SEC contends that, as in the Commonwealth case, Ripple's fair notice claim is irrelevant here. Commonwealth, like Ripple, contended that a 50-year-old Supreme Court rule addressing disclosure responsibilities was inadequate to warrant fair notice. So the SEC makes the connection between the two companies. The court, however, sided with the SEC, holding that enough notice had been provided. The SEC argues, first, that Howey and its progeny presented defendants with adequate fair notice to defeat their constitutional argument, since they established that lengthy Supreme Court law may offer fair notice. The SEC argues that the Commonwealth decision supports its petition for summary judgment and the rejection of Ripple's reasonable notice position. The XRP legal community does not think the letter makes any compelling points. According to yesterday's Bitcoinist post, defense attorney Jeremy Hogan considers the underlying technological question to be central to the case. If Judge Torres is familiar with blockchain and decentralization, he may consider a Ripple win as plausible. When asked about the recent SEC letter, Australian attorney Bill Morgan responded dismissively, saying, "There's no comparison. If you're worried about the SEC bringing this case to Judge Torres' attention because you believe the facts are similar to the case in which an investment advisor failed to make all necessary disclosure of potential conflicts of interest from which it benefited to retail investor clients to whom it owed fiduciary duties and whose funds it managed, then you're not alone." The founder of Hodl Law, Fred Rispoli, said that the letter is not super on point and may cause the judgment to be postponed even more. Judge Torres has been quite fair throughout this matter, always allowing the other side time to file a response to any extra briefs that have been filed. Rispoli says, Ripple could file a response to this in under 2 hours, but he anticipates a delay.